My name is Sabzada Zakiruddin Afridi. Arbad will represent your reason for breach of director duties. Faisal will represent your critical analysis, whereas Asad will represent relevance of the case in the development of corporation law. So the basically case study introduction is based on the Dr. Martin South was the managing and the chief executive officer of Select Vaccines Limited, and at the same time he is the director of the Martin South and Co. Private Limited, which is a trust, and the beneficiaries of this trust are dependent wife and children. Later, Select Vaccines Limited entered into an agreement with the defendant company only, that is Martin and South, under which the defendant company will provide the consultancy services on an agreed price, and apart from that, the company will get a benefit of the bonus. The bonus will be paid in a situation where the company share price will outperform the change, and determining factor of the same will be the Select Vaccines share price at the end of 31st December 2007. Well, according to the company share trading policy, let me discuss. It clearly stated in the policy that any director must, prior to trading in the securities of Select Vaccines, should inform the chairman about their intention to trade and ensure that they do not have knowledge of any unpublished price and sensitive information. In 2007, the defendant company had the trading account with the Commonwealth Bank, Australia, due to which the defendant gained the in-depth knowledge about the shares offered for sale. Well, there are three main instances issued which raised by the ASIC before the court, which are this below. The first one was whether the defendant company has breached any director duties. Second is whether the related party transaction in the present case is prohibited. The third part was about what are the remedies director breached their duties. Now I'm going to proceed to the Arbad to represent the reason for the breach of director duties. So Arbad, you can focus on that one, please.
Yeah, thank you. Alright, so I'm going to talk about the reason for breach of director duties. So Australian Exchange Commission, following the instance, has started their investigation, and they found the main director duties breach in this case fall under section 181 and 182 of the Corporation Law Act 2001. So according to section 181, a director of corporation should act in best interest of the company. Furthermore, present case defendant is the director of Select Vaccines Limited and Martin South Co. Private Limited. So in this case, defendant instructed Bell Property Security Exchange to purchase the share of Select Vaccines and manipulated share prices intention to earn short-term bonuses. Apart from that, defendant purchased purposefully the share of on the mother name just before the closing of trading, which shows the director did not act in a good faith. Furthermore, ASIC found breached his duty 181 following two reasons. Number one is defendant ordered personally. Second one is no evidence found proved that he got instruction from his mother name. Section 182, which was breached by the defendant, which says that gaining in-depth knowledge of trading practice, which comes under the misuse of position and not following the trading policy. So I'm going to pass it to my other member. He's going to talk about.
My name is Faisal, and my job is to put some light on the critical analysis of the decisions. As we see, the ASIC vs Martin South case is very important. In this case, the court penalized the defendant because the directors breach their duties. The company has a separate legal entity, but its affairs are being managed by the directors. So that's why it has become very important to regulate their actions, as their wrong decisions can take a company to the bankruptcy, due to which interest of the several stakeholders which are get affected. directors, if allowed to act on their own and powers are given to them. This decision is taken in 2015 and is from the Corporation Government Statement for the Tasmanian Council. And in addition, according to the Corporation Law Act, liabilities of the directors are limited. And in case company become bankrupt, then stakeholders and investors will be paid from the company assets. So it has been very important that directors should perform their own duties only while performing the function, and in case they're not following, then they will face the legal action against them. In the case of Essex versus Adler Court has analyzed the importance of the director duties, and it has been found out that the directors have to act in the good faith of the company and for the proper purpose of they should not misuse their power of their position. This has been described in the Duties 2016, a guide to the director duties and responsibilities for non-listed public companies and proprietary companies in Australia. Similarly, in this case, also suits have been penalized by the court by removing them from its position till further order. Moreover, he has to pay the penalty. This case shows that the judiciary has taken this aspect very seriously and have ensured that the directors are responsible towards the company and they should work only in the interest of the company. And now I just forward my next friend who will put some light on the other effects.
So, Mr. Siddiqui, I'll talk about the relevance of the case in the development of corporation law. This case is another important case which shed lights on the director's duties and explain how director duties enshrined under the Corporation Act 2001 play an important role. So, as going in past, Essex versus Adler is first important case after the implementation of corporation law in 2001, where a court has penalized the directors for using activities which have constituted the breach of directors' duties. According to these duties, directors should act in public interest and the companies and the investor of the company. Since Essex versus Adler, courts in several locations have identified the different activities which constitute the director's breach. In the present case, director has used his position to gain his own personal interest by manipulating the shares, and which is illegal activity. In this, main focus has been put on intention of the directors, and Essex have also done to investigate to find out that the purchase of share, the last one, was done intentionally or just coincidence. But it is found out that the defendant has done this with an intention to gain the bonus shares. This case has set a milestone for future cases also, that the director's duties don't mean that directors should perform the functions in the company with due care and diligence in the good faith of the company only. This case is identified as the director duties are very broad in nature, where directors cannot make personal gains, even if it's done within the frameworks of the law. Therefore, in present case, director might have used intelligence that the share purchase at the last moment will increase the price, but means to achieve the same is not acceptable. Decisions passed under the present case have a great impact on the operation of company. From the next company will be careful while making decisions when they have any kind of services from their own director company, and the companies in Australia will make rules under their constitution and in a strategic manner, so that the directors will more carefully while managing the affairs of the company. Dean Clearson, 2015. If henceforth the director is responsible to act under the favor of the company and the stakeholders primarily function under the corporation law. So the director just made his own personal gains through manipulating the share power.